So we're here today with Karen Churchill and Stephen Thomas, who have been doing some pretty hardcore campaigning against 5G to the point where they've actually had court cases. So we'll be discussing those. But before we get going, as you might know, we've already covered 5G a little bit on the channel with Ian Jarvis, and Karina has been into Colchester Council having a chat with them on more than one occasion. And every now and then we get someone in the comments saying 5G is perfectly safe, there's no problem, blah, blah, blah. Why do you guys feel it's not safe, and what evidence do you have for that? Why are you campaigning as strongly as you are?
10,000 studies showing that there are harms to from RFR, from 2G, 3G, and 4G. And these harms include headaches and sleeplessness and oxidative stress. 96% of all research, whether it's independent or industry funded, shows that there is oxidative stress caused by RFR as well as DNA damage. So the government narrative about safety, it does not include facts stemming from the scientific research that is on the table already. We have had court cases where it's been judged that acoustic neuroma has been caused by RFR radiation in the Court of Turin. And in August 2022, there was a High Court precedent set when a 13-year-old was awarded a low EMF environment for to accommodate her symptoms of electrohypersensitivity. So that was a long court case, it was an education health plan, but it has got a high court precedent rating, if you know what I mean. And it took 3 years to present the detailed biological scientific proof that the symptoms have a chemical foundation. So the narrative that anybody who experiences symptoms has created it through their mind is breaking down, as with many risks. Asbestos or smoking, has taken in the past court cases to show and put the science on the table, so to speak, to overcome the pressure from industry. It's very convenient for them to say very simply 5G is safe. And when you think about it, around a mast, there's an area where the exposure guideline limits are likely to be breached, called an exclusion zone. So within a certain distance from a mast, it is not safe. What is debatable is how far from the mast and how many people are affected by the radiation. So it is grossly inaccurate to say that 5G is safe or 4G is safe. 3 to 5% of the population are suffering from symptoms from exposure from radiation. And those worst affected can't live in their homes, they can't enter into real life. And the plight of this group of people is being ignored. And it's an absolute travesty and a tragedy. We have all these laws about equality, and if you have a wheelchair, you need a ramp. If you have EHS, you need a low EMF environment. And this is not being acknowledged. It's not being catered for. It's not being considered. It's not being considered by the courts, by the councils. We have this smart city rollout of a 5G trial in Bath. And the executive forward plan has just states that the risk is a perception of harm, and they're not addressing the actual risk of harm, which is very real and for which they have legal obligations to address.
Yeah, I mean, if it was safe, ICNIRP, for as hopeless as that is, wouldn't exist in the first place. And as many of our viewers will be aware, it doesn't cover anyone with a metal implant in their body, including fillings. That's not included in the safety guidelines. And am I right in thinking that in the EU, the exclusion zone of to how close you can have them to buildings, etc., is a lot further than in the UK, wasn't it? Like 10 times more, 500 meters, and here it's 50 meters. Can you talk about that a little, please?
Different countries have adopted different levels. Some countries have adopted a lower percentage of the ICNIRP. And in New Hampshire, there's something called the New Hampshire Commission, where they looked at all the epidemiology and the lab studies over a year. It was a legally commissioned commission. And the conclusion of that commission was that at least 500 meters setback from an average monopole is needed to protect the people within that radius. So there's another viewpoint compared to ICNIRP, roughly 50 meters from ICNIRP, 500 meters from the New Hampshire Commission.
That's quite a massive difference, because how much does it radiate out from when you're close to it to the distance? I mean, how far can 5G go? Because Ian, I think, was talking that it goes a lot further than they're saying it does.
Well,
It goes
again,
hundreds of, it goes, sorry, Karen, it goes hundreds of miles. But just to clarify Karen's point, the 500-meter setback was based on 5G, based off Kent Chamberlain's study. The existing exclusion zones around every mast are based on 3G and 4G. So those exclusion zones that you have seen, on the rare occasions they've been provided, that is based on 4G. It is not based on 5G. So it's really important to distinguish between the two. It can travel for tens, if not hundreds of miles. We don't know the safe distance, and people up and, councils up and down the country, they're not acting with precaution, which is the key thing.
Yes, it would be nice if they followed the precautionary principle. So what safety are the council meant to be looking at? Because a lot of them say we cannot refuse planning permission on safety grounds. Yet, from what you've just said, it sounds like they should be taking that into account.
They don't do anything. They accept these fraudulent ICNIRP certificates and they wash their hands of it. They don't entertain any ideas to do with health. I mean, the barrister in my case in Cheltenham stated, to his detriment now actually, that public health related matters are not to be taken into account during the prior approval process. He said that in black and white.
Blimey.
They don't consider health. They accept these fraudulent certificates. They don't check the details are correct, and they just pass them through. It's absolutely shocking.
What we're challenging them on is that the EU directives in 2018, something called the European Electronics Communication Code, was transposed into UK law, and the responsibilities of the local authorities to risk assess go back to 2010. But those responsibilities and obligations have not been made clear by the government to the local authorities. The opposite is happening, as the government is persuading the local authorities or leading them to believe that they mustn't touch health. So they've set a policy which says you cannot set health safeguards other than ICNIRP. Whereas in the actual letter of the law, it says that public health should be made imperative, and that the risk to the environment and the public health has to be weighed against the benefit. And it's how that weighting process is conducted, which Stephen and we are addressing with the government, because you need a procedure in place whereby the due process is followed. And this weighting of the benefit and the risks has to be, we're arguing, an evidence-based decision. So the evidence of the risk that objectors present need to be considered and taken into account and weighed against the evidence of safety, which it comes in the form of an ICNIRP certificate. So we are fighting through multiple levels for this, the technicalities of the legal obligations to be observed. And in Stephen's case, we did have this foot in the door, so to speak, when the judge ruled that, yes, the government should have taken the effect of onto pacemakers into account. He then made his own risk assessment that at 100 meters, it wouldn't be a big effect. And what
Was he an expert on such things?
Very, very wise of him, based on what information we do not know, but it's one of the grounds that we're appealing on at the moment. Yes.
Based on a fraudulent ICNIRP certificate.
Well, it didn't have the right, the barrister, the judge ruled that because the government haven't told Cheltenham Borough Council to check where the exclusion zone falls, and they haven't been told to check the details of the certificate, in his view, it was reasonable for them not to do so. And we're arguing it is unreasonable not to check them. So if the local council has to set a safeguard, which the wording of the policy indicates that they have to do, and we've had previous correspondence from the government's lawyers to show that they have the statutory obligation to weigh the risk and decide how much weight to put on that guideline. So it's very important that they realize that they have this statutory obligation, and the way they make that decision about how much weight they put on the guideline is based on logic, science, and evidence.
And what was that policy name again that they have to follow?
It's the National Planning Policy Framework, and it used to be 116, and I think it's 118 now. It could be 122. They've changed the number. But within that policy, it says that when they make the decision to approve or refuse a mast, that they must not set health safeguards other than ICNIRP's policy, and that's just advice. Because under planning law, they have procedures that they have to follow, and they have to make a reasonable decision, an evidence-based reasonable decision.
Sorry, just to jump in very quickly, you actually quoted what the barrister said, that LPAs must not set health safeguards different to ICNIRP. It doesn't say that. It said should not set health safeguards. And as you rightly pointed out, it's guidance only. How much weight they place to the guidance is up to them, but they can't obfuscate their obligations in planning law to take into account health-related material planning considerations, which in my case, there was someone with a pacemaker, there were people at the retirement home with hearing aids. The evidence provided by ICNIRP was provided to the case officer, and it was completely ignored. And the barrister said that, again, repeated the mantra that they must not set health safeguards different to ICNIRP. Well, it's not setting health safeguards to ICNIRP, because ICNIRP clearly state that these people can be affected at levels far below the limits. So it's just contradiction after contradiction. But I think what Karen was alluding to is that it is guidance, and everyone's been hoodwinked up and down the country to thinking it's the letter of the law. They kept repeating that famous line, we must not set health safeguards different to ICNIRP, and it's nonsense. They're not even following ICNIRP anyway.
Can I just say, from a health industry perspective, I'm a physiotherapist, and back in the day when it was popular to have electrotherapy equipment, there were pulsed shortwave diathermy machinery in the department. There was clear messaging outside with people with pacemakers. Mobile phones need to be switched off, because there wasn't research looking at all the cross mixing of whatever signals, the electricity, etc. In terms of people thinking that everything's safe, 3G, 4G, it has been normalised, and like you say, the messaging has been consistent over time. But to me, it's like saying paracetamol's safe. Of course it is. You take your dosage, but if you take 2 bottles straight away, we all know that that is going to be dangerous. So this is what they seem to be consistently ignoring. I have personally used that pulse shortwave equipment, and have had therapeutic effect that has been very profound, immediate, and long lasting. So it does tell me that we can interfere with the body system, but there is dosage that we're aware of and that we're using. And although that kind of equipment has fallen out of fashion, all the literature was there about, cardiac issues, pacemakers, not so much the neurostims that they've got now for things like Parkinson's, but all of that metal is important, and they are just seemingly ignoring it. So I would just like to ask, when you suggest that they need to exercise their full responsibilities, how do we manifest that practically? What questions do we need to ask? Where do we need to point to? Who do we need on side telling them that this needs to stop?
Yes, well, there's lots of materials on a website called rfinfo.co.uk, and there's some well-constructed objection letters in there which use the legal argument as well as the planning arguments. So that is one resource which is very useful. just to return to that, we need to start with the message that it is not true that they cannot refuse a mast on health grounds, because we have had an example in Mendip where the planning board debated the information for and against, and they did decide that there wasn't enough evidence of safety to proceed. So that sets the example that there is a legal pathway to refuse a mast on health grounds. So then it's a case of what is the latest and best information that's easiest to absorb for a counsellor or for a decision maker, a planner. And again, there's different areas of interest. You know, some people are particularly interested in the effect of children or on fertility. Some people are interested in the effect on the environment. Some people are interested in the political situation of how ICNIRP came into being. And we have arguments that address all these areas. And again, they're in the objections, and, they're ready to use. One of my favorite resources is the ICBE-EMF.org. It's a group of scientists, worldwide scientists, who are presenting one of their main papers is called the False Scientific Assumptions of ICNIRP. And it covers the deep science of the effects from 2, 3, and 4G, and it covers the inadequacy of our understanding of the higher frequencies that are going to be used in 5G, because 5G isn't as the shorter wavelengths aren't absorbed into the body as much, but it affects the skin and the eyes in unknown ways. And that paper lays out every single issue in very precisely referenced scientific report, and it's my go-to. It is a little bit scientific for a normal counsellor or mayor, but if they have the responsibility to protect the public, then they have a responsibility to become informed. And I think it's a good paper that bridges the science with the current issues, because I think a lot of people shy away of making an opinion on the science, but the paper highlights the issues as well as the technicalities about the science. And when considered as a whole, it's very clear that precaution should apply.
And the problem is, of course, it can't switch it off. It's on 24/7. So even if it's quite mild, over time, that is stressing the body, stressing the cells, because we may not be able to hear it or feel it, but it's constantly like a background for the cells. I mean, I happen to know 3 people that are sensitive. One of them's my mother, and I always thought she was just imagining it, because we don't have Wi-Fi in her house, but when we were out in Spain, that was your only option. And I'd be working away and she'd be like, can you switch that off? And it's like, yeah, okay. And then I'd forget or something, and then she'd come back in and say the Wi-Fi is still on. She would always know when it's on. It's like, how can you know? She's in my head, I can feel it. And another guy out there, when they put Wi-Fi in the town, he couldn't go in there anymore. He was that bad. That's the most extreme case. And we know someone here that also suffers. So it's not an imaginary thing, because I know too many people that are suffering, and then there's of course the ones that don't even associate various symptoms with it. I've moved house and got neighbours both sides with Wi-Fi, because again, I've always avoided it, because I was in an internet cafe and a guy came in from Switzerland, I think, and he said to the owner, you really need to switch the Wi-Fi off and get all your machines hardwired. And he said, I can't, I'm an internet cafe. And he told him in detail about the studies that had been done in Switzerland, and they were taking it out of schools. And that's just Wi-Fi. And that presumably is nowhere near the power that these other things like 4G and 5G are. So it's that constant saturation that is the concern. You might be okay with a little bit, but never being able to escape and not having any zone anywhere if they get their way and want to cover the whole planet in a grid of 5G. I mean, that's just quite terrifying. So it's so appreciative that you guys are out there battling it in such a high level, because you both got court case. Well, Stephen's had his court case, and you're actually taking the government on. So perhaps, Stephen, if you talk us through what you've done first, and then we can move on to what Karen is doing. And yeah, you guys are really going for it. So please tell us what your experiences were, Stephen.
As in where my court case is now, or just a
Well,
bit about
what you did from start to finish, because if people haven't seen you on Richard Vobes, then they're not going to know.
Okay,
the full
sure.
story.
So this time last year, a mass was approved very close to a retirement home, and also 17 meters away from residential apartments. There was no vertical clearance from the antenna. So normally these things are supposed to be quite high up. So the exclusion zones, the 4G exclusion zones go over the buildings. But in this case, there was no vertical separation. And that top of the antenna is literally blazing into people's bedrooms, kitchens, at the same height. And there's vulnerable people in there. There's a vulnerable lady. I won't mention her name, but she's got metal clips in her bowel. And she obviously found out about the impact on metal afterwards, so she couldn't object on it beforehand. So there's an exclusion zone breach. Lots of people objected on the proximity to their homes. There was the retirement home about 100 meters away, where there's lots of people with hearing aids, and I had objected on that basis, and I'd raised it as a material planning consideration. And I'd provided the ICNIRP guidance in my objection. Again, it was ignored. There was actually an objection from someone with a pacemaker in that building. Again, it was ignored. And in fact, Cheltenham Council just turned around and said that their prior approval wasn't even required.
Wow. How are they ignoring this, though? Is it because ICNIRP isn't, are they not recognising? How are they just saying, oh no, well, that doesn't matter?
Because as I said earlier, they're just accepting these fraudulent ICNIRP certificates.
Oh, I see. So they're basing it, even though you've proven they're false, and two, it's closer than it should be.
Well, I hadn't done that at the time. I hadn't shown them it was false, but that's their responsibility. They should check any evidence that's submitted to them. I mean, I've sent you the email from the planning inspectorate, which clearly shows it's their remit. It's not up for the public to do their job for them. If they're just going to rely on this one piece of crappy information, they best bloody well check it.
But as you know from our email stream with the leader of Colchester Council, it's just they just don't care about it.
They don't care, and it's shocking. So there was loads of objections. They decided their prior approval wasn't required, and that was it. I started working with Karen and Neil. I'd actually just finished a previous judicial review in Cheltenham somewhere else, which didn't turn out great, but it was a learning experience. So literally I had 2 weeks, 3 weeks from that, and obviously a financial setback to accompany it. And then this came up, but it was just such a strong case, I had to take it on. And I'd shown it to both Neil and Karen, and they were extremely supportive, really thought it was an incredibly strong case. So we kind of worked together, we got a claim in. It took a long time. It was firstly refused on papers. Then we went to a permission hearing where the judge ruled that both grounds were arguable. So then we went to a full hearing for a whole day. I had about 2 hours sleep, so I was almost like a zombie, and battled it out. And the judge partly ruled in my favour. He said that yes, there was a material planning consideration around the effect on people with medical implants at the retirement home, and it hadn't been taken into account.
But obviously, what does that ruling mean in real terms? Are they saying that should come down, or safety checks need to be done?
Well, this is the problem. He didn't quash the decision. So as Karen said earlier, he made his own risk assessment, saying that if those objections had been in the apartments closest in the exclusion zone, then it might be a different story. But there's two separate things. There's the exclusion zone, which is it's unsafe for everyone, me, you, Joe Bloggs. And then there's the effect on people with medical implants, which can be affected by frequencies much lower. And that has to be determined in a risk reconciliation, as Karen said, because the telecoms company didn't provide the power output. They didn't provide the power output. They didn't provide the exclusion zones. They issued a fraudulent ICNIRP certificate. So there's no way for anyone to check it anyway. It's just absolutely ridiculous. So it was a kind of semi victory. We kind of got our toe through the door in that sense. But obviously, he didn't go as far to quash the decision. He didn't make a ruling on the dodgy ICNIRP certificate. He said it was an administrative error.
Aren't they all? So now
Yeah.
what? How can you do anything? I know presumably you're appealing this.
Yeah. So just to finish though, but even when I pointed out that the ICNIRP certificate was page 1 of 4, and that the telecoms company had deliberately deleted pages 2, 3, and 4, the judge still thought it was an administrative error.
I've only ever seen one page. So what are the other pages then?
Well, it says in the bottom corner in my one, it says page 1 of 4.
Ah, okay.
And there's more technical information on the following pages, which obviously they don't want the likes of me and you to see for obvious reasons, because they're probably not ICNIRP compliant. And clearly 17 meters away from someone's home, it's not ICNIRP compliant.
No, it defies belief that they are, one, accepting that fraudulent certificate, and two, it's even within the guidelines, 17 meters is too close. That should have been an open and shut case, surely.
Well, what should have happened is that they should have checked where the exclusion zone was. There was an objector who had asked them to obtain the exclusion zones. And
each mast is different depending on the power of it, or is there just an exclusion zone?
There is an exclusion zone around every mast. It's generally the same size for the ground-based structures, and they have like fix-it solutions where they can dial it down. But I obtained, and I think I sent it to you, the compliance manual from 3 themselves that they use, and it showed the different fix-it scenarios.
No, you haven't sent that to me, but if you could, we'll
I'll send it to you.
Yeah.
But even in the most conservative situation where the fix-it is deployed to dial down the power to its minimum functioning amount, that exclusion zone is 28.5 meters and 4.5 meters clearance vertically. And
how do you know it's operational though? Because they could say it's fitted, but that doesn't mean to say they've turned the volume down on it.
Yeah, they can't dial it down further than that for it to be operation, for it to work properly. So that's like in the most extreme example, they'll dial it down to a stage 4 fix-it solution.
But how do you know they've actually done that?
Well, we don't. They're probably going to have just the normal output to begin with, and if people complain, then they can dial it down, but they can't dial it down further than a step 4.
The thing is, the public need to be checking when every application comes through, because if the councils aren't doing it, clearly we need to, don't we, to check that exclusion zone.
Well, yeah, and I don't know if you saw my Richard Vogue show, but the telecoms company deliberately concealed these exclusion zones. Yeah. We've got evidence from an exclusion zone where they left the text on there saying that exclusion zones must not be shown to any member of the public or planners.
Yeah, or the contractors or anything. I saw that. Yeah.
Yeah, it's insane. So where's the public health protection? And what's really sickening is the fact that the council know it's in an exclusion zone. They know full well, because I submitted the compliance manual as part of my evidence, and they fought tooth and nail for it not to get heard in court. And wow. They even tried to bring in their own fake exclusion zones the day before without following due process, without obviously showing it to me or submitting it formally as evidence. They just came up with these exclusion zones like the day before the hearing. I mean, luckily the judge didn't want to hear it, but this is the extent of the fraud that they're committing. They're willing to falsify documents because they know full well that it's not compliant, and they know that, and they don't give a damn, and they're just going ahead, and all they care about is making sure that it goes up, and they get their little backhanders.
It sounds like they know full well it's not safe, not just
Yeah.
that it's meeting those requirements, which aren't, nobody knows for sure if that will do anything.
They're under a lot of pressure from the government not to enter into any kind of engagement around health and environmental effects. And this is where Neil and our case come into it, because within the EU directives, which were totally ignored in Stephen's case, where we lay out the policy and the recitals and the articles, which lay out very clearly that there is a procedural standard that has to be followed. They haven't enacted that procedure. They haven't informed or created a policy in line with that legal obligation. And so what Neil and I have done, we've collected evidence across the country whereby the government have not clarified when they were asked directly, the Department of Science and Innovation and Technology were asked directly, what is the jurisdictional obligations to risk assess under the EEC. They did not answer that email. We asked Matt Warman MP, who was the leader of DCMS, Digital Culture, Media and Science, are the local authorities competent authorities under this directive? And he answered, well, where they're already considered competent, yes, they are competent. So it was a rather vague answer, and he didn't, expand on the issue beyond that. And what we found is that he may have answered in that way because this role does go back to previous directives. So it's not just under the EEC that this obligation for shared mass, the public consequences, health consequences, do fall under the remit of the local authority. So this is the battle we're in. We've collected the evidence that some councils say they are a competent authority, some say they're not, some say they don't know. We have Mendip, who's refused a mast on health grounds, and we have many other councils, if not the majority of councils, saying that we can't refuse a mast on health grounds. So these conflicts and contradictions are in our evidence bundle that we've gone to the government and say we want. Last September, we requested that they resolve these contradictions and they clarify what the jurisdiction is. And we say that policy needs to be changed in order to bring in a telecom-specific impact assessment. And they didn't address our submission. They didn't address the contradictions. They didn't address the auditory effect, which is 100th of the ICNIRP basic level at around 4 volts per meter, is being seen breached on streets all over the country. And the local authorities are not informed about it. The public are not informed about it. And that was one of the elements that we wanted to bring into the impact assessments. So with our case, we presented this in September. We didn't get a satisfactory result or answer to any of our points. And so we filed the judicial review application. Again, the same judge is in Stephen's case, dismissed the case as without merit. There wasn't one word of analysis of our presentation and the evidence we presented. And the defense are saying that our case is about regulation and that we should be challenging Ofcom and that we're out of time to make this challenge. So they've completely ignored the local authorities' responsibilities. And this is the Achilles heel. This is the battle. They don't want the local authorities to have the responsibilities that they have. It will slow things down. They will have to make them competent to make those decisions. And obviously they're not. So this is what we're fighting for. We're fighting for the letter of the law and for them to not wriggle out. Because the other case I was involved with, I was one of 3 claimants in a case called Action Against 5G, which was led by Michael Mansfield. And with that challenge, we were challenging the government's choice of the guideline. And we gave the government a lot of evidence, scientific evidence, why that choice of guideline was inadequate and is a breach of human rights. Now, the Judicial Review Court and the Administrative Court are very slow to get involved with the actual technical scientific details. And that's the way they defended not entering into our evidence. So in that case, it was decided that the government had done enough by choosing that guideline. So the case didn't result in what we wanted, which was a change in the policy of using ICNAP. So this is why we are now challenging the government about the relationship between the government and the local authorities and this gap in regulation that is happening in the way the guidelines being applied, because it's not being applied. It's a fake sham regulation. They're not applying it. They're not checking that the public are protected. They're following the pressure from the government not to do a thing.
Because I donated some money end of last year for your fundraiser. Was that for this one, or was that something else?
It's ongoing, and we're appealing the first judge's decision of dismissing. So we're appealing to proceed. But also we're fighting cost capping. We've had 2 judges judge that our case isn't about the environment and it's not about a planning issue. Well, clearly it's about environmental effects. Clearly it's about a planning issues. So yes, we just had that second judgment. And again, there isn't one word of analysis that addresses any of our arguments. The analysis of the recent judge is purely picking up points from the government's side of the argument. So I'm shocked, I'm disappointed, I'm really disappointed at the quality of decision making by the courts.
As
Stephen has, it's in the administrative court, and we're appealing to the Court of Appeal. But the quality of decision making, the quality of analysis is extremely poor. And the first decision had 5 points, all lifted, just 5 points lifted from the defence's argument, and they're not logical. It hasn't addressed pages. I think it was an 81-page submission that we submitted with full evidence of these contradictions. There was a complication with our case because with judicial review, you usually have to challenge a decision within 3 months, I think, for a central. And obviously, they construed our case that we were challenging the transposition, where we're not. We're under exit law. There's a provision to challenge if there's an incomplete transposition which is affecting rights within 3 years. You have this provision to make a challenge. So that does make it a little bit complicated, but nonetheless, the principles are very clear. It is about local authorities having an obligation to risk assess.
Can I just jump in just very quickly? Because on that note, you talk about the government doesn't want councils to risk reconcile. That's exactly why Cheltenham Council are also appealing what happened in the High Court. So I'm taking it to the Court of Appeal, and so are they simultaneously because of the ruling on pacemakers. And there was a statement from a senior planner at Cheltenham Council stating in his own words, saying that if this is allowed to stand, it's going to mean that councils up and down the country are going to have to perform this reconciliation, something which they're not equipped to do. He also went on to say that it disrupts the speed of the rollout. This risks seriously disrupting the speed of the rollout up and down the country. And I'm just like,
priority is how quickly they can get it out, not whether or not it's safe.
Exactly.
Say it out loud, right?
They actually said it.
Okay.
Exactly, and it just makes my blood boil when I read it. They just don't give a hoot about public health.
The thing is, their families are going to be exposed to it.
Yeah.
So what on earth is going on? I mean, so much for the letter of the law, but if our legal system, and I've got a lot of people that say, oh yes, if you can get it to the High Court, Supreme Court, blah blah blah, it'll be fine because the higher up you go with the judges, they know the law, they won't break it. But I hear so many cases of them just ignoring the law, and this
I think
exposes that.
I think the useful thing is when you're, for example, in Bath, when they've started this agreed to roll out a trial of up to 20 masts all connected across the city. And when we're challenging the council, once we know we have legal rights and where those legal rights are, then it puts us in a strong position when we're talking about the issue. It moves it from an opinion to a right. And so I think it's very useful that we know our rights, we know where they stem from, and we keep asserting our rights, because it puts us in, as I say, a stronger position, even if we have to keep fighting in cases that's what happened with smoking. You don't win on the first case. Eventually, the tide turns. So
the more they roll out, the harder it's going to be to get them to take them down. So if you can get in and stop them with the rollout now, it's going to be easier and better for everyone in the long run.
That's what. So we've challenged Bath, and we put in a notice last Friday, and we did a 4-page, legal argument, which is now with their legal department. And we're going to inform the public that we've done that, so that they are exposed in their process now. So if they don't go ahead and risk assess, they've got the public scrutiny. And so we want as many people to come to Bath on the 7th of July, and we're going to be outside the council building. And Sandy Adams is going to be there talking, as is Tess Laurie from the World Council for Health. And we're going to have leaflets, and we're going to inform the public about what's going on. So we really welcome people from all over the country to come, because this is an issue. If we can stop it in one place, then it'll help everybody in other places. And there's a website about it, a page on rfinfo.co.uk/smart city. And you can find the latest research there and pamphlets to download.
And will it be filmed as well?
We're looking for a photographer, so if there's anyone out there who'd like to step forward, that would be super.
Because those speeches and the crowd, to get that onto video, and we'll happily share it on the Council Watch channel as well, just the more that they can see, look, this isn't just a couple of weirdos, in each council kicking up. This is like lots of people are concerned about it. Certainly, yes. I think we've got the Essex Residents Association here, and they do lots of leafleting. They keep an eye on the council, and also they go around speaking to people. And a lot of people are concerned. It isn't just a few people, it's a lot, which is good, but it's not getting through with the council. And that is the big battle that we're having at the moment.
We have stopped 68% of all mast applications in the last 3 years. That was a statistic from about 3 or 4 months ago. And in Bristol alone, we've had 99 masts refused. So our kickback, we need to keep at it, but it shows that taking action does have an effect.
All the links in the description so that people can follow that, so that they know how, because if you've done all the hard work of getting the objection letters done, then it's going to be so much easier for people to do this and put up objections.
Yeah, and just quickly, because just to talk about Corinna, because I think you'd sent me.
I sent you the email
where again they're just gaslighting, pretending they don't know what's going on. And I did watch your videos, Corinna, from a month or two ago, when you provided them the planning inspector email, you've shown them the company's house information, and for them to turn around and say, oh, show us the evidence. I mean, it's just pure gaslighting. What I can do, I can send you a list that I've used in my appeal, where 3UK Limited is being used. And obviously that's just that I think there's like about 150 examples there. So you can turn around and say, look, Mr. Council, I've given you all the evidence. Here's all the evidence here of another 150 or so applications. And in some of the applications, they've actually physically typed Free UK Limited onto the declaration.
Well, we've
So it's
sent
not a
them
job.
one in Colchester that they've approved. I mean, there's about 5 or 6 when we did a quick search. We haven't gone through it exhaustively, but we've actually given him the number to look.
Yeah, and it's just typical gaslighting and stonewalling when you provide them
Willful
evidence.
blindness. They don't
Willful
want to
blindness.
see it, do they? They can
But,
manufacture consent by just continuing with the messaging.
yeah.
Yes,
But,
so that's where we just continue. We continue drip, drip, drip. You know, each of us taking responsibility and joining in, you know, the continual sort of sharing of information, solid information, accurate information, and that's what gives us our strength. Eventually, it will tumble. I think.
Relentlessness, that's what it takes. And it does, believe me, it does.
Mm.
Is there anything else you'd like to, either of you would like to say, or Karina, for as we wrap up?
maybe Corinna, because yeah, we both, myself and Karen, have done a lot of talking, but maybe Corinna wants to kind of just kind of update us what's happening in Colchester, because I haven't seen too many videos lately from down there.
Particularly the response I got from David. I haven't had time to look into that, but I want to pick that apart. I know in one of the videos that Rachel's done already, there's a bit where he's sort of saying about, you know, it was all quite confusing and maybe the other counsellor understands a bit more. So I'm going to let him know that I'm not confused in any uncertain terms about what the issues is. And if he'd like me to explain it to him personally one-to-one, I'm quite willing to give my time to lay it out so that he can understand what our concerns are. So yeah,
Right.
there's another one coming.
Well, you've got to wait 6 months. They've changed the rules now at Colchester Council. You're not allowed to bring the same issue up unless there's a 6-month gap, and also you're only allowed to ask one question now and have your say. So
yeah, they're doing not
ideas up my little sleeves. We shall be Operation sort this out. It's coming very soon, but we need to do one more reply and then we'll take it from there. But yes,
the middle-aged women in cardigans are not going away. So, yes, hopefully they'll start to listen. We'll have to force them.
Great work. No, great. Really like what you're doing down there. So keep it up.
And yes, best of luck to both of you with what you're doing. And Karen, how's your fundraiser going? Do you need more help with that, or is it going to depend on what happens with the judge now?
We certainly do, because they filed a bill for 36,000 for writing 2 defence letters.
Ooh.
36,000. So obviously we're fighting it, but yes, we do need help. I think we're on around 6,000, and we've already had expenses to come out of that and filing expenses. So yes, please do share the fundraiser. That would be really wonderful.
It just demonstrates how strongly swayed the judiciary is to people who've got money. The big corporations, you know, they can continue on this, whereas we have to sort of scrabble together to fight it when really the council should be fighting on our behalf.
And it's people like Stephen and Neil who are willing to put their whole life and their financial support into this in order to create cases for us all to benefit from. So they really do. Neil and Stephen deserve our support. And a little by everybody makes a big difference.
Precisely. If everyone donates a £5 before you know it, you've got covered.
Yes.
Thank you both for all that you're doing. You're taking it to, you know, the really next level, whereas we're just going and battling with the council. That's bad enough. But for you to be taking them to court, it's, you know, power to you both. And thank you so much for all you're doing.
And that will inspire some of us to take that next step and actually put the spotlight on individuals or councils that need to be held to account.
That's great news. Lovely, Karina. And thank you for all the outreach and your wonderful, clear videos, because it makes a big difference.
Yeah, we've got to spread the word. So yes, we'll continue. If there's any videos you want us to share, especially of your event on the 7th of July, let us know and we can happily pop them on the channel.
Thanks so much. Keep up the great work, guys.
Yes, and we'll hopefully speak again. So once you've got some
great.
And meet one day, even if it's not July this year.
Yes.
Yes, I'd like that.